hear me?
Yes, sir.
All right. Well, good afternoon all, and welcome to Seyfarth Shaw's PAGA webinar series, Let's Talk PAGA, Navigating Shifting Case Law, New Theories and Defense Strategies. And the first in our webinar series, PAGA Peculiarities. My name is Jeff Westbrook, and I'm a wage hour and complex litigation partner for Seyfarth Shaw in Sacramento. Today and through the end of the year, we will be hosting a series of webinars discussing the most unique and challenging aspects of PAGA, everything from class settlements or PAGA settlements to manageability at trial, standing, civil penalties, and the like. Today we're offering a half hour of CLE credit, and I'll share the code word for that towards the end of the presentation. We have a lot to cover, and we will do our very best to answer any questions you might have. There's a Q&A box on the side of your screen to use. If we're not able to answer your questions today, with apologies, we will absolutely answer them after the presentation and get to them ASAP. Today's presentation is for informational purposes only. Our discussion shouldn't be construed as legal advice. I'm joined today by my esteemed panel of PAGA litigators, Daniel Wang, who's a wage hour partner in our Century City, Los Angeles office, and Shireen Wetmore, who's a senior associate and PAGA guru in San Francisco. On cue for today are some PAGA peculiarities, starting with PAGA Standing. I think the differences between PAGA representative actions and class actions, the rise of the PAGA-only complaint, a lawsuit asserting one cause of action under PAGA as opposed to a dozen individual labor code violations, and finally, civil penalties versus statutory penalties, the differences between those. Today, as the name of our series implies, we'll be talking about PAGA peculiarities. I know that's a hard one to say. What makes PAGA different than a class action and other wage and hour type suits? Minimal standing is something we'll address at the outset. Representative versus class actions. We'll also touch on barriers to federal jurisdiction, why PAGA suits, or at least PAGA-only suits, end up in state court and stay there. To frame our discussion, we thought this graphic would help show really the rise of the PAGA suit in being embraced by the plaintiff's bar. Since 2004, when PAGA was enacted, we've seen almost every year an increase in submissions with the state called PAGA notices that have to be submitted before a PAGA lawsuit can be filed, with last year breaking a record. I think it's clear that PAGA is a favored vehicle for the plaintiff's bar to sue for labor code violations and civil penalties. It is at least very much here to stay, and which is why we're presenting to you with this webinar series. Before we jump in, though, with our first PAGA peculiarity, I'll pass it off to my colleague Shireen to just give us a minute explanation of what PAGA is so that we have a little context before we go in. Shireen?
Thanks, Jeff. So let's start with the very basics. What is PAGA? The Private Attorney General's Act is a procedural vehicle for Californians to sue employers for civil penalties for labor code violations as though they are the state. Wait, that doesn't sound right. The California Department of Industrial Relations explains it like this. The Labor Code Private Attorney General's Act authorizes aggrieved employees to file lawsuits to recover civil penalties on behalf of themselves, other employees, and the state of California for labor code violations. As in, every California worker transforms into an attorney general? Yes, pretty much, which is peculiar, right? Hence why we're here. So before 2004, when PAGA went live, only the state could seek civil penalties for labor code violations. PAGA fundamentally altered this approach, and in doing so, it created a new private representative action vehicle that allows individuals to act as state and sue for civil penalties based on labor code violations that the would-be litigant personally suffered, as well as for penalties the labor code violations that other similarly aggrieved employees experienced. The purpose is to address a perceived need to increase enforcement of the labor code, and how better to do it than by letting the employees police their employers directly. Now the state, specifically California Labor and Workforce Development Agency, the LWDA, must still be notified before a PAGA suit is filed and given the chance to issue a citation or to investigate the claim. But as many of us know, the LWDA almost never does either of those things. So after waiting a prescribed period for the LWDA to take action, a PAGA litigant may file an action in court. And that's pretty much it. PAGA in a nutshell. Back to you, Jeff.
Well done, Shireen. All right, so let's dive into our first PAGA peculiarity, PAGA standing. And I should note at the outset that as with most things PAGA, the state of the law is in flux. And we're seeing new cases every year defining and redefining the scope of the law. And indeed, just last week, as we were preparing for this webinar, a court of appeal issued a new standing decision that was published. So we should keep that in mind as we're discussing sort of generalities about the law. But from a litigation standpoint, standing is an important defense that employers use to achieve dismissal of a class action suit, to identify differences between the class representative and the broad class he seeks to represent, to show that the claims aren't typical, that there's commonality issues and other ways that we can drive a wedge between the class representative and the group that he seeks to represent. Standing's different under PAGA, and unfortunately, it's fairly minimal. And as Shireen suggested, the California Supreme Court has noted that that was an intentional part or a design of the law, that the legislature wanted broad enforcement of California's labor laws and thusly created a minimal standing standard in the law itself. So what is standing under PAGA? Well, it provides a private right of action for individuals to sue for civil penalties under the labor code. Before PAGA, civil penalties were a thing that only the state could collect. It wasn't on the table in private lawsuits. So that's a big change that PAGA brought about. Not only did PAGA do that, it creates a private right of action for labor code provisions where there wasn't and is not one. So individuals can sue for labor code violations under PAGA seeking civil penalties that they could not sue for a labor code violation for damages themselves. PAGA provides a default civil penalty to apply where labor code provisions don't have a civil penalty itself. So some labor code provisions have a civil penalty, and PAGA action would allow that to be enforced. PAGA goes the extra step and gives a civil penalty to those labor code provisions that don't have one, which makes it unique. PAGA defines standing not in terms of damages or economic loss or injury or even the labor code claims that the PAGA plaintiff brings, and that makes it very much a different animal. Standing under PAGA is about the labor code violation that he has suffered, regardless of injury. And this was a big part of the court's discussion in the Kim v. Raines International Supreme Court case just this year, where a labor code litigant brought a lawsuit not under PAGA, seeking damages and statutory penalties, and settled that case, receiving money to compensate him for his alleged damages. And the Supreme Court held that even though he had settled those individual claims and received money and was made whole, he still had standing under PAGA because he suffered a labor code violation, which was a shock to most of us defense litigators. But there's much to distinguish about the Kim v. Raines case, however, because the settlement agreement itself didn't address PAGA claims at all. In fact, it specifically carved it out. So there are ways to distinguish that case. So standing under PAGA has two basic requirements. The PAGA plaintiff has to have been employed by the alleged labor code violating employer and suffered one or more labor code violations. That's essentially it. It's important to note that under the Huff versus Securitas Court of Appeal case in 2018, the PAGA plaintiff doesn't have to have suffered the same labor code violations as the group he seeks to represent. So a PAGA plaintiff can sue for labor code violations he didn't even suffer, which is completely different than what we see in the standing context in class actions. Now the Huff case was not, has not yet been addressed by the California Supreme Court, so it's not settled law, but it's out there and it's of course being used by the plaintiff's lawyers. And then a quick note related to standing about administrative exhaustion requirements under PAGA. Shireen hit on this, but the administrative exhaustion relates to standing, but it too is minimal. PAGA plaintiffs only have to file or submit a notice with the state laying out the facts and theories underlying their labor code violations. They have to give notice to their employer, wait a certain amount of time. The state almost never acts in response, and there we go. They have standing and have exhausted administrative requirements. During that period of time, employers may, depending upon the violation, cure certain labor code, alleged labor code violations. That'll be a topic we'll discuss in one of our webinar series in December, I believe. And with that, I'll turn it over to Daniel to discuss our next PAGA peculiarity, the representative action. Daniel?
Thanks, Jeff. As Jeff mentioned, there are definitely some peculiarities and differences between a PAGA representative action and a class action. I suspect that many of you appearing for this webinar or participating are probably familiar with the class action. So we wanted to highlight some of the key differences to explain why PAGA is an entirely different animal. The best way, and probably the most intuitive way to understand the differences, starts with the fact that a PAGA action is in fact a law enforcement action brought essentially as a representative of the state of California. Both a PAGA action and a class action start as individual. There is a single plaintiff who file a lawsuit. The difference is that in a class action, that individual is in fact that individual. So if Joe brings a class action, in that class action, he's bringing his claims as Joe. If Joe were to file a PAGA action, Joe is not Joe per se, but Joe is in fact an agent now as a proxy for the state of California. And therein lies the key difference. In a class action, if that single plaintiff were to get the class certified and is able to establish there's a community of interest or an ascertainable commonality among the class, then it becomes a vehicle to aggregate the claims of other individuals, and that can now proceed as a class action. A PAGA action is different in that the individual is a representative of the state, and there isn't an aggregation of individual claims. Instead, that person is able to bring an enforcement action that only the state of California could previously bring, and a private individual could not. And because of these differences, there are also different procedural requirements. A class action, you need to establish the class certification requirements, at least in California state court. It's fairly well settled that you need to establish the requirements under CCP 382. In federal court, the cases are mixed, with more cases than not finding that Rule 23 does not apply, apologies, to PAGA actions, but there are a minority of district court opinions that have held that Rule 23 does apply. Nevertheless, in a PAGA action, however, in state court, it does not need to establish the requirements for a class action because conceptually it's an individual bringing a claim on behalf of the state of California. But given these procedural differences between a representative action and a PAGA action, there are also differences in terms of the ability for somebody to participate or not. In a class action, if a class is certified, putative class members are given the opportunity to opt out of the class action, and they decide they don't want their individual claims to be part of this class action. They want to reserve the right to bring their claim later, or they just don't want to participate at all. That same option is not available to a potentially aggrieved employee who's a member of a PAGA action. Member is probably the wrong word, but somebody whose rights might otherwise be adjudicated in a PAGA action. In other words, if somebody is a potentially aggrieved employee and this PAGA action proceeds, they don't have the option of opting out of the PAGA action. Whatever if there is a determination that there was a violation, then that individual potentially aggrieved employee would subsequently be bound by the PAGA adjudication. However, as we will discuss shortly, there are key differences in terms of what the remedies are in a PAGA action versus a class action. In a class action, since it's an aggregation of individual rights, it's the individual remedies that otherwise would be available to those individuals that are being adjudicated. In a PAGA action, since it's a law enforcement action, it's only those rights that the state of California could have previously brought that are actually being adjudicated. But nevertheless, if a potentially aggrieved employee is bound by a PAGA judgment, they themselves wouldn't be able to step into the shoes of the state of California later to adjudicate the exact same rights that have been resolved in an existing PAGA action. The other thing to keep in mind is throughout the PAGA action, even though the potentially aggrieved employees might be able to receive some civil penalties as a result of an adjudication, they nevertheless aren't individual participants in the PAGA action. And that's because a PAGA action doesn't have individual rights per se. It's not an individual claim. Whereas in a class action, it is that individual's claim that is being adjudicated. So that's a high-level overview of some of the differences between PAGA and class actions. We'll get into that a little bit more when we talk about the differences between civil and statutory remedies. With that, I'll pass it back on to Jeff.
All right. PAGA only complaints. That's Shireen?
Yep, that's me.
All right.
And yeah, we're just going to talk for a couple minutes about this popular new res of PAGA only complaints. Jeff had a slide about it at the beginning of the presentation. But I guess the first question is, what is a PAGA only suit? It's just what it sounds like, a lawsuit where only one cause of action is asserted, and that's a PAGA claim. Individual claims under the Labor Code for unpaid wages and statutory penalties, as opposed to civil penalties, which Daniel will discuss next, those are not asserted. What's interesting about a PAGA-only suit is that a lot of potential damages are left on the table by plaintiffs. So why are so many plaintiffs and their counsel bringing them? Let's start with what's left on the table. PAGA claims are subject to a 1-year statute of limitations. Compare this with 3-year statutes on labor claims, 4 years under California's unfair competition statute. That's a lot being left on the table. There's unpaid wages for off-the-clock work, miscalculated overtime rates, or unpaid meal and rest period premiums. Those are not available under PAGA. Meal and rest period premiums, remember those? They're an hour of pay at the employee's regular rate for short, late, missed, interrupted meal or rest breaks. Those can really add up. But all of that is being put aside. PAGA claims are strictly limited to civil penalties and, of course, recovery of attorney fees and costs. So plaintiffs' attorneys are strategically declining to limit their claims periods by a third or more and their recovery when they bring a PAGA-only claim. But why? Plaintiff lawyers know that PAGA-only actions are more challenging to defend than labor code actions for many of the reasons we've highlighted already. And they know this because employers' procedural defenses to labor code claims for damages and statutory penalties are in many cases either unavailable or more limited in PAGA cases. For instance, obtaining federal jurisdiction in PAGA-only actions is difficult. The Ninth Circuit just held last month in Canela v. Costco that PAGA penalties should not be aggregated to reach the amount in controversy requirement. And PAGA actions are not class actions for the purposes of the Class Action Fairness Act, or CAFA. The court in that case ruled that PAGA actions are not sufficiently similar to Rule 23 class actions to trigger CAFA jurisdiction. So a PAGA action is more likely to stay in California state court, where pleading requirements and discovery decisions are more employee-friendly. Also, class and representative action waivers and arbitration agreements do not apply to PAGA-only suits. The California Supreme Court in Iskanian v. CLS Transportation Los Angeles held that the Federal Arbitration Act does not preempt state law as to the unenforceability of PAGA waivers. A key distinction made by the Supreme Court in Iskanian is that PAGA actions are not the type of private disputes that are subject to arbitration agreements, because a PAGA action is in reality a suit by the state, aka the LWDA, against an employer. So arbitration agreements involve a waiver of an individual employee's rights, but the state is not a party to that arbitration agreement and therefore cannot be bound by it. Since Iskanian, employers have tried creative ways to use arbitration agreements to split claims, delay PAGA suits, or waive issues relating to PAGA claims without much success. The employer in Perez v. U-Haul Company of California 2016 appellate court case, for example, tried to compel arbitration of individual aspects of a PAGA claim, including the plaintiff's status as an aggrieved employee. But consistent with Iskanian, the court held that the arbitration provision undermined the public policy goals of PAGA and that it was unenforceable. In addition to these hurdles, PAGA-only suits, as we discussed, are not subject to state class certification requirements, which is a key way to dispose of a class action. Seat certification, and likely the case goes away. We're going to discuss motions to strike PAGA actions, manageability, and trial plans in our fourth webinar series. But avoiding class certification proceedings is a huge incentive to bring a PAGA-only suit. In addition, obtaining summary judgment is often difficult in PAGA cases, as labor code claims frequently turn on factual issues, such as whether an employer authorized and permitted rest breaks based on staffing, scheduling, and other issues. And with nearly all PAGA actions stuck in California state court, employers are left with California's liberal and employee-friendly discovery rules, which is the topic of our next webinar in September. But all these issues equal settlement pressure. Couple that with enormous civil penalties, and it's no wonder that PAGA-only claims are on the rise. And now we're going to turn it over to Daniel to cover our last topic of today's webinar, those civil penalties. Daniel?
And I'll actually jump in real quick and give the CLE code before Daniel starts. SS0887, SS as in Seyfarth Shaw, 0887. Daniel?
I think you might be on mute, Daniel.
My apologies. As previously mentioned, a PAGA action seeks to recover civil penalties that a labor commissioner or the state of California previously could only award. Now, just want to cover briefly the difference between a civil penalty and a statutory penalty. And this relates to the differences between a class action and a PAGA representative action. So in a class action, they're able to, the plaintiff as well as putative class members or class members are able to recover statutory penalties and remedies which they individually would be able to recover had they brought their own individual lawsuit. In a PAGA action, however, the recovery is only for civil penalties, which the state of California could only previously provide. Now, Labor Code actually uses the word civil penalties throughout to indicate which provisions the labor commissioner could previously award civil penalties for. So one example would be for the underpayment of wages, Labor Code Section 558 provides a civil penalty in the amount of $50 for an initial violation and $100 for any subsequent violation. And that is an amount that prior to the enactment of PAGA, the labor commissioner could award. There are many, many other labor code provisions, however, that do not have a corresponding civil penalty associated with it. The PAGA statute, however, provides a default PAGA penalty, as Jeff mentioned previously, for those provisions that don't have an articulated civil penalties scheme built in. The default penalty is $100 for the initial violation and $200 for every subsequent violation. And we'll get into what the initial violation versus subsequent violation means, but I wanted to go through one example of what the different penalty schemes might actually look like under the Labor Code. So you could have, for instance, Section 1174.5 provides a civil penalty of $500 for the willful failure to maintain certain employment records. Built into that is a willfulness element. But other civil penalties don't require finding a willfulness. As I mentioned, Section 558 provides a civil penalty of $50 or $100 for the underpayment of wages. But another claim that a lot of employers face is a reimbursement claim, failure to reimburse necessary business expenses under Section 2802 of the Labor Code. And there isn't a corresponding civil penalty provision associated with Section 2802, in which case the default penalty under PAGA of $100 for the initial violation or $200 for the subsequent violation would apply. And so that's just one example of different types of schemes that are present or that could apply to different violations under the Labor Code. The Labor Code does mention initial penalty or initial violation versus a subsequent violation. And there was a decision in Amaral, which was a published Court of Appeal decision, that did provide some clarity on what initial versus subsequent violation means. The initial violation, according to that decision, is any violation that precedes notice being received by the employer that a violation has actually taken place. And we take that to mean that there's either been an adjudication by the Labor Commission, a citation, something along those lines. And prior to that taking place, the employer is not on notice of any violation, and therefore only that initial violation would apply. It is only after that notice or determination is made that the subsequent violation would apply. The plaintiff's bar typically will argue that what the statute actually means is you get a penalty of, let's say, $100 for the first time any employee suffers a violation, and the following pay period is $200 for every violation that precedes that initial violation. But the Amaral decision states that that is actually not the proper interpretation. Just really briefly, also just want to mention how civil penalties are calculated, in the sense that it's not based on shift, it's not based even on work week. Instead, the PAGA penalties are based on pay periods. And so you can, let's say you have an underpayment of wages, again, the $50 on the $100 penalty, whether that individual suffered 1 day of underpayment of wages or 5 days of underpayment of wages or even 10 days of underpayment of wages if the employee is paid biweekly, the amount of the penalty remains the same in terms of the maximum amount of penalties awarded. It is just based on the pay period, not, again, based on the shift or even the work week. Because these penalties were previously only able to be recovered by the state of California, PAGA also provides that any civil penalties recovered in an action, 75% of that will go to the state of California, and then 25% will go to the potentially aggrieved employees. And that's, again, because the state of California previously was the entity that otherwise could have recovered these penalties, and they remained a real party in interest in a PAGA claim. And I know we're quickly running out of time, so just want to hit 2 quick points really quickly. One is stacking of penalties, and what that means is for a single type of violation, let's say underpayment of wages, whether there can be multiple penalties associated with that. A common argument by plaintiff's counsel is that if you have an underpayment of wages, they should be able to be entitled to the 558 penalty for underpayment of wages, a wage statement penalty because the amount of the wages is inaccurate on the wage statement, as well as waiting time, a violation of Section 201 or 202 of the Labor Code, and they should get a penalty for that. So in other words, there are multiple penalties stacked on top of each other for a single violation. And the law is unsettled as to that, whether stacking is permitted or not. One other quick point is even though we've been talking about these penalty amounts, that is the maximum amount of penalties that are fixed by statute. PAGA provides that the court has the ability to exercise its discretion to lower the PAGA penalty amount. There is a Carrington versus Starbucks decision, one that we like to cite to frequently, where the potential amount of civil penalties was $70 million. The court ended up awarding a small fraction of that, a little over $100,000. And so that is one example of a court exercising its discretion to reduce the penalty amount. So we'll see these inflated exposure numbers by plaintiff's counsel, but that doesn't necessarily reflect the reality of what a court might actually award. There's many other things that we could certainly go into in terms of civil penalties. It's the one area of PAGA where we see the room to make very novel and creative arguments. But since we're at the top of the hour, I will hand it back, or top of the 30 minutes, I'll hand it back to Jeff.
Thanks, Daniel. And thank you all for joining us for our first series and Seyfarth Shaw's PAGA webinar series. I hope you'll join us for Series 2, Discovery Practice and Sequencing, and the other series in our PAGA webinar presentations. Be on the lookout for an email from us on CLE submission that's coming. And apologies if we weren't, for not being able to answer your questions. We'll get to those ASAP after our presentation. If you have any questions following our presentation, feel free to reach out to us. Thanks again for joining.